Okay, so what we're going to do is just, tonight we're going to go into the basics of this stuff, and you guys may know a lot of this, if not all of it. I'm going to try to put some stuff in there that you may not know, but for a course like this is obviously unavoidable. I know what it is. I got the share down too low. That's better. Okay. All right, so we're going to start with the basics, and in the next few weeks we're going to be delving deeply into some primary sources that I can attest. I mean, I did get a PhD at Columbia University, and they didn't teach me any of that stuff. That's stuff you got to learn on your own. So tonight we'll just get the basics, and then during the question period, then we can get into whatever level you want to with this stuff. So okay, so the idea of nullification, and I want to start off very, very basic for people who are coming at this. Also, we have some people who are not Americans, so I don't want to take for granted any prior knowledge. So we're going to start with the most basic thing. What is the idea of state nullification? And it is simply the state refusal to allow the enforcement of an unconstitutional law. Well, what makes a law unconstitutional? Well, in the American case, of course, we have a written constitution. So for a law to be unconstitutional in the American sense, it's different from in the British sense, where they have an unwritten constitution. So the British case, something is unconstitutional if it violates long-standing tradition. If it violates customary practice, that makes it unconstitutional. In the American case, we actually have a document in black and white. And so if the federal government exercises a power that's not given to it in the Constitution, then it is behaving in a way that's unconstitutional. If it's defying some express restriction on its behavior, then it's defying the Constitution. And that would be an unconstitutional law. And the consensus among Americans, regardless of where they stood on nullification, was that a law that violated the Constitution was not a law at all. So by and large, the American founding fathers were not legal positivists. They were not arguing that because the Congress has passed a law, that makes it constitutional. That was not their position, that it had to conform to the Constitution. Otherwise, it was not a law. Then the question becomes, well, who determines that it's unconstitutional? And that's really when we get into the meat of nullification. Because the idea of nullification really gets its classic expression in Thomas Jefferson and his Kentucky resolutions of 1798, which you would have read in their actual text and read about in the reading for this week. And for Jefferson, it is not the case that one simply consults the courts. And I will address that Article 3 question that somebody asked about. We'll talk about that in the question and answer period. But rather that it was the role of the states. The states are the sentinels of the people's liberties, at least vis-a-vis the federal government. And this derives from the fact that the states, in fact, created the federal government in the first place. And we'll be talking about that a little bit later as well. Right now, all I want you to understand is that it's the states that ultimately, in the last resort, are the guardians of the Constitution. In the last resort, they are the guardians of the Constitution. And in the super-duper last resort, it's the peoples themselves, the peoples of the different states, assembled in convention, who are the ultimate arbiters of constitutionality. So that is to say, if there is a completely intractable dispute between the states and the federal government, then it need not come to blows. We simply refer it to the people assembled in convention, and they can assign whatever the disputed power is to either the federal government or the states and settle the matter once and for all. Now, following on the heels of this idea of nullification, I want to introduce the term Principles of 98. And this term is a reference to the year 1798, and the significance of that I'm sure you know after having done the reading, but we will get to it on the next slide in any event. But I want to introduce this term, the Principles of 98, and we can summarize them as follows, that the federal government is a government of limited and enumerated powers. So that is to say, the federal government is not a government of unspecified powers, where it's given a general legislative authority. It is not given a general legislative authority. It is given enumerated powers. So that is to say, it can't appeal to some unspecified reservoir of powers. It must refer to some portion of Article 1, Section 8 of the Constitution, which is where the powers of the Congress are, the legislative powers are listed. It must refer to that portion of the Constitution to justify what it's doing. So the federal government has only the powers that are delegated to it in the Constitution. The rest of the powers are retained by the states or the people. And then I put in parentheses, this is really what the 10th Amendment to the Constitution says. The Constitution is ratified in 1788, and the 10th Amendment is ratified 3 years later as part of the Bill of Rights, which are the first 10 amendments to the Constitution. And the 10th Amendment says precisely this. And I'm also noting that the 10th Amendment is implicit in the Constitution as drafted. In other words, strictly speaking, you don't even need a 10th Amendment, because this was the understanding everyone was given at the state ratifying conventions. When the Constitution was drafted in 1787, it was sent out to the states for their approval. And in those ratifying conventions, which is where we are told to look to understand the meaning of the Constitution, we find that people are being told that this federal government has only these enumerated powers and no others, and that the federal government has only the powers that are expressly delegated to it. So in fact, they use language that's even stronger than the language of the 10th Amendment, which merely uses the term delegated. In the state ratifying conventions, we hear the term expressly delegated. So they're very, very clear about this. So it's up to the states then to decide whether or not to ratify, and that's why we're told by James Madison, who played a key role at the ratifying convention, at the Constitutional Convention of 1787. James Madison later became the 4th President of the United States. It was Madison who said, if you want to know what the Constitution means, you really need to look at the ratifying conventions. And the reason for that is that that's a kind of common legal principle, that you always want to know what are the intentions of the people who settle on a document, who approve of it, who ratify it. And it's the states who are giving their approval. We need to know, what did they think they were getting themselves into when they approved this Constitution? Let's hear it from the horse's mouth. So we go there, and that's where we find this being vindicated. Now, the states, a number of them, were concerned about the absence of a Bill of Rights in the original Constitution, and some of them entered into a kind of a gentleman's agreement with supporters of the Constitution, saying, we'll go along with this document as long as you pledge that at the first opportunity you'll introduce a Bill of Rights that will specify particular things that the federal government cannot do. And particularly they insisted on something that, like what became the 10th Amendment, that there be some official statement to the effect that the states retain all powers they have not explicitly given up. So the Bill of Rights, the way one of my friends puts it, is the Bill says that if there's anything we forgot, you can't do that either. That's basically what it is. But now here's really the linchpin of the Principles of 98. If the federal government engages in a dangerous violation of the Constitution, so notice that that's specified in the resolutions of 98, that it has to be a dangerous exercise of authority to advert to nullification. If there's a dangerous violation of the Constitution that takes place, the states have to stop it from occurring, from deforming the original Constitution. You can deal with lesser violations through means that are not quite so dramatic, like the ballot box and so on, but something that really reaches to the heart of the regime, something that overturns the America that everybody thought they were living in, namely the Sedition Act, as we'll see in just a moment. That needs to be challenged by the states. The states have to the extent that it's in their power, refuse to allow the enforcement of the law in question. Okay, so where does the idea come from? Well, I said that it receives kind of its mature statement in Thomas Jefferson in 1798. We'll get to that in a second. But it's not Jefferson from whom the idea emerges fully formed. And so here I'm introducing to you what I mentioned in the text, and that is the importance of the Richmond Ratifying Convention. Now remember that Virginia is the biggest state at the time, population, but also if you look at the size of Virginia, Virginia is a big state today, but Virginia included land that would today amount to many other states as well. In fact, Virginia ultimately yielded many of its western land claims, and Maryland was upset at Virginia, wanted it to yield these western land claims. So it was an enormous state, and of course many very important American statesmen hail from Virginia, so the ratification of the Constitution of Virginia is particularly significant. And it's worth noting that even after all the assurances that skeptics of the Constitution were given about, oh, don't worry, it's not going to have all these crazy powers you think it'll have, even after all these assurances, Virginia still voted to ratify the Constitution only by a vote of 30 to 27. So still extremely close. So I point out specifically the skepticism of Patrick Henry. Patrick Henry was a great hero. He had been known for fighting against the Stamp Act against the British in the 1760s, and was a great orator. And so Henry was, his opinions meant something, and he was concerned that a clause like the General Welfare Clause, which appears in the preamble to the Constitution, although that's not so significant because a preamble doesn't have any legal significance. But it's also in Article 1, Section 8, there's a reference to the general welfare of the people. And he was of the belief that the governments, you give them an inch, they take 10 miles. You give them a clause like this, well, obviously, every tyrant who ever lived claimed that everything he's doing is for the welfare of the people. So what's to stop this government that we were assured would be a limited government, and what's to stop it from becoming an unlimited government? And it can point to a clause in the Constitution justifying that. And what's significant about this exchange is what the Federalists, who are, what's the term for supporters of the Constitution, what they said to Patrick Henry. And in particular, there was a 5-man committee that was established with the task of drafting the document by which Virginia would officially ratify the Constitution, if it chose to do so. And that 5-man commission included the 2 people I'm mentioning here, Edmund Randolph, who became the first Attorney General, and George Nicholas, who became the first Attorney General of the state of Kentucky. So these are people of no mean legal knowledge, that's for sure. And it was they in particular, so not just a couple of random bozos, but a couple of people who were, number one, supporters of the Constitution. So these are not skeptics of the Constitution, but supporters, and people serving on this 5-man ratification document commission, who said 2 things. Number one, this is a limited government only with the powers expressly delegated to it, so the federal government will not be able to appeal to some general welfare clause to override the specific limits on its powers. But secondly, as George Nicholas said, if Virginia found that the federal government was attempting to impose upon it any supplementary condition, any additional power exercised by the federal government, then Virginia would just be exonerated, because Virginia would simply be able to point to the language of its ratification and say, now wait a minute, when we ratified, we said we are ratifying, we're entering this union on these terms and accepting these particular federal government powers and none other. So if there is an additional power exercised, then Virginia would be exonerated from that. So that's pretty close to the idea of state nullification. And the key source on this, if you were interested in reading on it further, is somebody I refer to in the text. That's Kevin Gutzman. And I say that not simply because he's a friend and he and I wrote a book together once called Who Killed the Constitution, but because Kevin has really done an exhaustive research on this. Oh gosh, I'm sorry, I'm getting a Skype request. It's making noise. Let me turn this off. I've never had that happen to me before in the midst of something. Let's quit Skype entirely. Sorry about that. I'm busy right now. Okay, good. All right, what am I saying? Yeah, so Kevin's book is called Virginia's American Revolution, and Virginia's American Revolution is an expanded version of his doctoral dissertation at the University of Virginia, and it's an excellent, excellent book, and I think you'll be pretty convinced by the evidence there that you can make a good case that there was an original intent that there would be indeed such a state power of nullification. Okay, let's see. I'm going to skip this for a second. Okay, yeah. I guess I put this slide, maybe one slide earlier than I wanted. So let's skip it for now, and then we'll go back because I do want to introduce the resolutions of 1798. And again, forgive me if this is stuff you guys know. We'll get into much meatier stuff in the question period, but one can't neglect the basics at the very beginning. It was in the 1790s, again, as we note in the text, that in Virginia there are repeated reminders of the language that was employed at the ratifying convention and the conditions on which Virginia ratified the Constitution. And so when 1798 comes along and Jefferson comes out with a full-blown doctrine of nullification, This is something that had been germinating for years. It wasn't something that emerged full-blown out of his own head. And it emerged, though, in 1798, specifically under the pressure of the Alien Sedition Acts of 1798. And the part that gave people the most concern was the Sedition Act, whose provisions made it a crime punishable by fine or even imprisonment to be critical of the U.S. Congress or the President. My wife asked me, so when do you want to eat tonight? I said, I'm stuffed. I had a huge lunch. I'll eat after the thing is over tonight. I'm just not hungry. And now suddenly in the middle of this, I'm dropping dead here. So I hope I'm coherent. And then at the 10-minute break, I'll wolf down some food and then come down and look at your questions. So it was in response to the Alien and Sedition Acts that Jefferson and Madison drafted the Virginia and Kentucky resolutions of 1798. So the Virginia resolutions come from the pen of Madison, and the Kentucky ones from Jefferson. Now, Jefferson, remember, is the vice president at the time in an administration that indeed signed the Alien and Sedition Acts into law. That's John Adams. So Jefferson does this anonymously, although there were suspicions that Jefferson was involved, and then years later it becomes known to everybody for sure that he was involved. And it was in these documents that we hear precisely these ideas. The Kentucky resolutions, the first draft of them used the word nullification, but a skittish Kentucky legislature dropped that word, but the concept was still clearly given voice to in that document. Then follow-up resolutions in 1799 in Kentucky then indeed introduced Jefferson's term and phrase that a nullification in a situation like this is the rightful remedy. In the Virginia resolutions, we've got James Madison using the term interposition, which calls to mind the image of the state standing between the federal government and the aggrieved people of that state, standing in between those two, interposing its authority to prevent the execution of an unconstitutional law. Now, as we'll talk about in the question period, as I see somebody ask about it, we will talk about what Madison meant in the Virginia resolutions. Perhaps he meant something that was not as thoroughgoing as what Jefferson meant, although the two were in contact with each other, although it was hard for them to engage in a lot of written correspondence because Jefferson was concerned that Federalist postmasters were opening his mail, but they did speak to each other about this and they were in some contact about it. And basically the idea here is that nobody would allow, if you ever enter into a contract, nobody would allow the other party to that contract to interpret it exclusively. Both parties need to have some way of interpreting it and making their interpretation felt. But also the theory of the Union on which Jefferson proceeds doesn't actually view the U.S. government as being a party to a contract. It's not like we got the states and the federal government and they enter into a contract with each other and both sides need to interpret the terms of that contract. It's not even that. It's much more than that. It's that the states entered into a compact with each other and they established a federal government as their agent. But the agent is not a party to the contract. The agent is a product of that contract. And so, strictly speaking, the federal government is not a party to the contract at all. It is the states themselves who have entered into a compact among themselves. So all the more is it the case that the parties to a compact would in fact be judges of infractions of that contract. Infractions, whether infractions have occurred, and then also the mode and measure of redress, what form that redress should take. So this is nullification, and there are some northern states that indicated their opposition to this idea, that wrote responses to the Virginia and Kentucky resolutions. Virginia and Kentucky resolutions were passed by the legislatures of those states, so trying to give the most solemn state voice short of a state convention that the states are capable of. And some northern states said, oh, this is just crazy, it's some kind of crazy talk. But I point out in the book that overwhelmingly the reason that they were against the Virginia and Kentucky resolutions was that they were in favor of the Alien and Sedition Acts themselves. So naturally they're going to be against what Virginia and Kentucky are saying. They actually approve of these acts. Massachusetts said it was a wise thing for the federal government to enact the Sedition Act. Hoping that water could substitute for food. Okay, off we go. I do want to make brief mention of Madison's report of 1800, which is excerpted in part 2 of the Nullification book, because the occasion of that report was precisely the Virginia legislature wanting to review its own doctrine, wanting to review the Virginia resolutions of 1798, and in light of the criticisms they'd received from other states, and upon sober reflection, decide whether or not, in fact, they should modify, revise their initial statement. And basically what Madison says in the report is that, no, I think we were right the first time. And what Madison is saying is that, yes, we have much respect for the judicial branch of our government, but we need some remedy for the peoples of the states for when even the judicial branch fails them. And that's, in effect, what they're talking about, is some kind of state recourse. So it is worth noting that if Madison had meant to say something other than this, if he had meant to say something other than the states can indeed prevent the enforcement of a law they consider unconstitutional, now was the time to say so, because the whole country thought that's what Virginia meant. That's what the country was objecting to. If Madison had simply meant to say the states reserve the right to protest against unconstitutional laws, nobody would have disagreed with that. Nobody denied that. There'd be no point in even writing that up, because no one had ever denied it. So this would have been the time for Madison to say, now, whoa, 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 you people have all misunderstood me. This is a terrible misunderstanding. No wonder you're so upset. I understand. I would be against it too if that's what we said. He says nothing of the kind. He ratifies the earlier statement of Virginia. I think that's a useful historical clue. By the way, my friend Kevin Gutzman, who has both a JD and a PhD in history, so the lawyers are afraid to debate him and the historians are afraid to debate him, he's actually working on and finishing the last chapter of a biography of James Madison's coming out next year called James Madison and the Making of America. And he is very impatient with, I mean, he says that, look, I think Madison actually had some very admirable personal qualities. I think he was indeed very, very intelligent, very bright. But he said when Madison in 1830 claims that he never intended to say any such thing and everyone has just misinterpreted him, I said to him, this is years ago, I said, Kevin, what do you make of that? And he said, well, of course he's lying. Very blunt, Kevin Gutzman. Okay, next, oh, pardon me, the slide I skipped. One of the documents that I wanted you to take a look at this week, and I realize this is kind of a lot of reading. I know you guys you're busy people. Since I'm not testing you in this course, I figure I can get away with assigning a lot of reading because, what's the worst that can happen? You just don't do it. Okay, that's all right. It won't hurt my feelings. I have no way. I don't have psychic powers. I don't know if you did the reading or not. It's okay, but I'm just telling you that this is what I would like to talk about during the session, so this is what you might want to take a look at. And I do talk about, if you do want to take the course for a grade, that by the last day that you submit, and I'll open up a window to submit this. I got to ask Grace, and I've never done. I did multiple choice quizzes in my course on the New Deal. I haven't done this before. I'll figure out how it's done. We'll open up a window for you to submit of just 4 or 5 pages. You'll find in week number 4 that I've assigned. I have a PDF of a whole book, and you just find one of the essays we didn't read in that book. One of the essays speeches not by Webster or Hayne, and then just tell me about it. Just what are the basic arguments here, how are they relevant to what we've been talking about? But it's the chapter 9, Roman numeral 9, and the text starts on page 217. I was so delighted to be able to publish this. This is a pamphlet, as you note from the italicized introduction, that appeared first in early 1833. Abel Upshur was a judge, Virginia judge, who later served in the cabinet of John Tyler, and then died in an explosion aboard a ship. So he's he was in middle age when he died. But Upshur, this pamphlet here, an exposition of the Virginia resolutions of 1798, is something that I just came across completely at random. I was doing some research at the Columbia University Library, and I just happened to come across this pamphlet, and I realized the significance of what I just found, because I actually think this may be the most persuasive argument for state nullification I've ever seen. And here I am looking at it. I quickly photocopied it, and then I found that it was reprinted in a magazine 2 years later, 1835, and that's it. This pamphlet has not been heard of since that time. So it's incredible for me to have this chance to get it back out there and publish it and resuscitate it. It's stunning to me, and I assigned it to my students at the time back when I was teaching college kids in New York. And beautiful thing about assigning something that hasn't been published in at the time I was teaching, that would have been 170 years, is that nobody's written anything on it. And nobody's written any cheat sheet essays on it. So these poor souls had to actually read it for themselves and write about it for themselves, heaven forbid. But what he's doing here is just laying out some important points, because even at that time, you had James Madison sort of in the twilight of his life trying to deny that he had ever supported this idea, that the Virginia resolutions ever meant to convey this idea, and that Jefferson himself would ever have endorsed this idea. And then it was shown to him that, well, here's a copy of the draft of the Virginia resolutions in Jefferson's own handwriting, and he uses the word nullification. And so Madison had to withdraw that argument. But it's interesting that I have had debates online with professors at top universities who still cite Madison and Madison's quotation about Jefferson would never have supported nullification. They still cite that as if it wasn't refuted in 1833, as if it wasn't, or 1830, as if it wasn't refuted at the time. It was refuted by showing Jefferson's own document in his own handwriting, and Madison actually withdrew that statement, and yet they're still quoting it. So there's your historical profession for you. But I love this when you look in here. I obviously can't see what I'm holding up, but he's got this great numbered series of arguments where it just leads you inexorably to the idea of state nullification. What he's doing is he's pointing out that if you look at what the Virginia resolutions are calling for, they're calling for some measure that will stop the progress of the evil being the federal government's usurpation of some power. Usurp is to exercise a power that belongs to somebody else. So if I started assigning professors to various courses in the Mises Academy, I would be usurping the authority of Grayson. So the evil that's referred to in the Virginia resolutions is usurpation. And Upshur considers all the forms of resistance short of nullification. So, say taking up a petition or whatever, all these other forms, or seceding from the Union and all these other things. He says none of them actually get to the heart of the matter. None of them actually arrests the progress of the evil. If you secede, the evil still persists over, it's still being exerted over other states. If you sign a petition, well, that's probably not going to be strong enough to arrest the progress of the evil. So he says, by the terms of the document itself, the only remedy that would work would be nullification. I want also to explain what he means in here, because it may not be obvious, by the term revolution. And what he's getting at here is that it was alleged by opponents of nullification that because nullification, in their view, was not a constitutional remedy, then it really amounted to, it was a revolutionary power. It was not a power that was exercised under the aegis of the Constitution. Okay, so it's not, so what Upshur's trying to argue is that this is not a revolutionary power. We're not overthrowing the Constitution. We are operating very much within the parameters of the Constitution. We're operating under it because the very act by which the Constitution was ratified and the terms on which the Constitution was ratified, all these things point to nullification. And indeed, there is no other way to prevent the exercise of unconstitutional power. So all we're doing is exercising state sovereignty, a sovereignty that is acknowledged by the Constitution. So in other words, we're acting within the confines of the Constitution. So we are not engaged in revolutionary activity. We're not overthrowing the Constitution. We are acting within it. And then finally, I think Upshur does a very good job, and we can talk more detail about this in the discussion, but I think it does a very good job of listing what the objections to nullification might be, and then assessing them and answering them. It's a very scholastic kind of presentation that he's got here. And so he, for example, entertains this argument that, well, wouldn't it just be completely chaotic? That you'd have some states nullifying some, like every state would have to judge every single federal law. This would surely be crazy. Yeah, I'm not so sure how crazy that would be, but surely this would be unworkable. And Upshur replies to that. He said, well, I think that the states, they created the Union in the first place. They obviously see the utility in it, so they wouldn't destroy it themselves. But more than that, he says, let's consider the two possibilities. One possibility is the states don't have this power, and so the federal government can just enforce all the unconstitutional laws that it wants. That's one form of abuse. The other form of abuse is that the states just nullify everything, whether constitutional or not. Well, which of these forms of abuse is the more dangerous? I mean, obviously, okay, if states nullify some salutary law, I'll try and flip through and find one. But if they were to do that, okay, big deal. So for some period of time, we have some states not enforcing the law. But what is that in the scale of offenses in the world compared to the federal government behaving as if it has no limits on its power? Okay, let's move on. So we'll get back to this one. Okay, we'll just review this very briefly because this is rather self-explanatory. You can find it in the text. There's a whole chapter on it. But it is revealing that the very New England states that purported to be so appalled at the Principles of 98 in 1798 and 1799, wellity, it turns out that when their ox is being gored, all of a sudden they love these ideas. And I think some of the quotations, and my chapter is not exhaustive. You can find other quotations from New England at this time objecting vigorously to the embargo that Thomas Jefferson imposed. It was an embargo that said that no American ship could leave for any foreign port anywhere in the world, and the reason for this was to punish the British and French for their depredations on American commerce on the high seas, because the British and French were, of course, at war. They had been at war. There have been the wars of the French Revolution, and now we're involved in, we see the Napoleonic Wars raging. And each side was interfering with the shipping, even the neutral shipping, going to the other side. So Jefferson didn't want to go to war over this. I mean, even if he had intended to go to war, the U.S. military was completely unprepared for a war like that. So he engages in what he calls peaceable coercion, which is not, in fact, an oxymoron. It's to try to use the instrument of trade as a weapon. And his view was that these countries were so dependent on American trade that all we have to do is cut off American trade and they'll come begging us. They'll say, gosh, what do we need to do to restore American trade? And Jefferson said that they will be delighted to learn that the only thing they need to do to restore American trade is simply to deal with us fairly. That's all we're asking. So Jefferson attempts this policy. It is highly unsuccessful. It's the most unpopular policy of his two terms. This is, by the way, late 1807, and then the embargo was withdrawn in early 1809, and then Madison tinkered with it a little bit in his presidency to try to get it quite right. You might wonder, why does Jefferson prohibit, this is just a parenthetical thing, why does he prohibit ships from going to any foreign port? Like, why doesn't he just punish the countries involved? And the answer was, of course, that once a ship leaves an American port, like, there's no way to stop it from going to any country it wants to. So just don't let it go anywhere in the first place. And now, of course, Americans were good smugglers and they had ways of evading this, but still it was really quite devastating to the maritime economy of New England. And the searches and seizures, there was a very low threshold necessary for officials to search your ship and seize it on suspicion that you intended to engage in export to some non-American port. I mean, you could sail down the American coast, but you can't go beyond the coastline. So a lot of ship owners are upset about this, and you see a lot of protests. You have New England states officially registering protests and speaking about that they are not subject just to what some federal court says, that federal courts can be wrong and they can uphold things that are outrageous against the Constitution and natural rights and morality. And so, in fact, we even have Connecticut saying that state officials should not lend their assistance in carrying out this embargo. So this is serious stuff. Daniel Webster will later try to minimize this, but I think he's wrong. Just saying that we are going to be the judges of constitutionality here, that's really quite something. And then later even, there's an attempt to interfere with the carrying on of the War of 1812. In New England, we see the refusal to allow their militias to be called up on the grounds that none of the conditions for the calling up of the militia laid out in the Constitution were in fact met, and so the governors had to interpose and say, no, we are not going to allow our militias to be used for the invasion of Canada. That's an offensive measure, and that's not what the militias are all about. So this is serious stuff. Okay, then we have the best-known example of nullification, and it's the actual incident is referred to as the nullification crisis. 1832 to 33. I'm going to give you the brief overview of this. This involves a tariff dispute, and it begins with two documents. They're sometimes mistakenly thought of as being one document. They're actually two documents, as I explain in the text. There's the South Carolina Exposition, and then there's the protest. Oh yeah, I'll get the, yeah, exactly, thank you. Yeah, I'll get to the questions later. Okay, so South Carolina is unhappy about the tariff of 1828, which was imposing tariffs that were reaching 50%, just about 50%, the highest that had ever been enacted. And they argued that these tariffs were unconstitutional. They were at the very least of dubious constitutionality. On the grounds that, although the Constitution does indeed give the federal government a power to levy a tariff, that this tariff was understood to be for revenue purposes, not for the purposes of protecting domestic industry. Except to the extent that a tariff for revenue would incidentally also be a tariff of protection, because any tariff is going to discourage people from buying foreign goods to some degree. But that would just be incidental to the fact that the tariff is really intended for revenue. This was clearly not a revenue tariff, and South Carolina protested on these grounds. This is going to destroy their economy, and there were numerous southern states that objected to this in the 1820s. The South Carolina Exposition and Protest was anonymously drafted by John C. Calhoun, who was the vice president. Okay, well then there's an attempt to, well, let's try to work within the system. Let's see what can be done. And by 1832, you get the tariff of 1832. This doesn't really do anything to help the situation from the point of view of the southern states and South Carolina in particular. And so it gave them no relief from the tariff of 1828, which had been referred to by disgruntled Southerners as the Tariff of Abominations. Now, another aspect of this story is that Calhoun was, at this time, continued to be the vice president under John Quincy Adams, who was elected in 1824, and then he's also the vice president under Andrew Jackson, elected in 1828. Well, his relationship with Andrew Jackson really begins to break down over the course of Jackson's first term, and you can see a couple of really significant episodes here. The first one involves Andrew Jackson's role in the acquisition of Florida. In the administration of President James Monroe, there was the argument was made that Florida, which had been held by the Spanish, was called a derelict province. So that is to say, Florida was so badly governed that there were bandits and Indian tribes that were coming over the border from Florida, and they would attack people, let's say, in Georgia, and then just jump back over the border into Florida and say, you can't get me because now we're in Florida. And so the argument that the U.S. government was making was that because Spain is doing such a rotten job, because Spain, of course, has a million headaches now throughout the Americas with revolutionary revolts they've got to put down. They don't have a lot of personnel now in Florida, so things are getting a little bit out of control. So the argument then becomes, if you can't govern this area adequately, then by right, the possession of Florida ought to pass to some force that can govern it effectively, and guess who that would be? So they sent Andrew Jackson in with a very limited mission, just to give a show of force and see what happens. And Jackson decided pretty much to take the whole thing, or take a good chunk of Florida. And moreover, Jackson had a couple of British subjects executed, and there was some concern now he was becoming an embarrassment. There was some concern on the part of the administration in Washington that perhaps he was going to ignite a war with the British in the crude way he's handling this Florida matter. I mean, Monroe was sort of perhaps secretly happy to get Florida, but not quite with the way Jackson's going about it. The British, in fact, decided it didn't want to go to war with the U.S. yet again, And so that passed, but there were people back in Washington who were saying that perhaps Andrew Jackson should be just made ambassador to Russia and get him the heck out of here. And then Monroe and others were saying, if we make him ambassador to Russia, probably will wind up being at war with Russia within 3 weeks. So, but Calhoun at the time was serving in the cabinet, and he said Jackson should be recalled and punished for this, for going beyond his instructions. Well, it's right around this time, during Jackson's first term as president, that he discovers this, that he finds out that the guy who's now his vice president was, back at the time that he was serving in the administration of Monroe, was stabbing him in the back over Florida. That's the way Jackson views it. So there's one incident. The second incident that leads to this tension between the two of them is something called the Peggy Eaton affair, E-A-T-O-N. Peggy Eaton was the wife of John Henry Eaton, who was in the Jackson cabinet. And the thing with Peggy Eaton, now I don't know the ages of those of you who might be in the chat room, so I want to say this as delicately as possible. But let's just say that before she married Mr. Eaton, Peggy Eaton, well, let's just say she knew a lot of congressmen very well. She had a very close relationship with a lot of congressmen. Let's put it that way. So when she gets married to John Henry Eaton, and now Eaton is in the cabinet, and there are a lot of social functions. Yes, Rob, that's exactly right. She had a bit of a reputation. So there are social functions. Something like kick in my neck here. That take place in the White House with the cabinet members and their wives. And so there would be this awkward situation in which John Henry Eaton would show up with his wife, Peggy Eaton, and the other wives don't want to talk to her. They would shun her. They wouldn't invite her to things. And Jackson was convinced that Calhoun's wife, who had referred to Peggy Eaton as a hussy, was behind this. This was another way that Calhoun was trying to undermine and embarrass him and cause dissension within his administration. And so to fight against this, Jackson was insisting that the wives include Peggy Eaton. And he, in fact, he said that all these stories about her are false, that she was pure as the driven snow, which was perhaps overstating the case. So in any event, this was a big disaster. He couldn't persuade them they wouldn't let Peggy Eaton join in their reindeer game, so to speak. So this was another source of tension. And finally, when Andrew Jackson doesn't like you, you usually decide you just want to get the heck out of there, which is indeed what he did. So Calhoun, in fact, resigned from the vice presidency and returned to South Carolina and decided that he would come out in the open and fight against the tariffs out in the open on the floor of the U.S. Senate. He was elected. There was an open U.S. Senate seat, which he then was elected to. So then he gets back into Washington, but on the other side of things. Jackson later said that he regretted not having had Calhoun hanged. And incidentally, as a grammatical point, indeed, when we're speaking about execution, the word is not hung, but hanged. All right, so now you got back and forth. The way Jackson looks at this is that this is just simple insubordination. This isn't, a sovereign state is interposing over a disputed question of constitutionality. No. Jackson thinks of this the way he would think of it as a military man, that this is mere insubordination. They have no right to do this. And so he issues a proclamation regarding nullification that is in fact not drafted by Jackson himself, but by his Secretary of State, Edward Livingston. And we're going to look at that. I think that's actually next week. We're going to look at that document, and then we're going to look at a response to that document. This is very, very good stuff to get to know. Well, so now it looks like, nobody's going to back down here. Because by the end of 1832, Jackson is starting to gather troops, and South Carolina has a special nullification convention on the grounds that they believed that they were engaged in an activity that was so significant that it needed to invoke the highest sovereign authority of the people of the state. And just so you know, the American system, the understanding of the American system is not that the states are sovereign per se, but that the peoples of the states are sovereign. And the people then exercise that sovereignty at the highest possible level when they convene a convention, a special convention. And so given that the highest voice of the sovereign people comes through the intermediary of a state convention, that is how a constitution would be ratified, and that is how they believed we ought to engage in nullification. So they did that, and they said we're going to nullify these tariffs. So it looks like this is just going to be a disaster. But eventually, cooler heads prevail. Nobody's going to have a civil war over a crummy tariff. So cooler heads prevail. Henry Clay brings about a compromise. Henry Clay is a U.S. senator from Kentucky. And his compromise is, well, what if we lower the tariffs gradually over the next 10 years? His argument being that this gives the South satisfaction, but it also gives the North time to adjust. So that, their markets don't have to be thrown into turmoil overnight by an immediate cancellation of the tariffs. And this sort of soothes the feelings of both sides. It sort of gives sort of face saving for both sides. Okay, let's continue on. And then, yeah, oh, look at this. All right, this is an interesting graphic by Grayson here. I like that a lot. Yeah, watchmen and police officers of Boston. Wow, isn't that great? That is fantastic. Very, very interesting. Yeah. This is one of these posters warning you if you are a colored person, so in their language, that is to say you are what the census term is a free person of color. That's the term that the census of 1860 used, living in the North. You better be careful because some of these officials might actually cooperate in the execution of the Fugitive Slave Acts. Oh, very interesting. There's a very good handbill that I quote in the book in Wisconsin, in which they say we have to exercise our powers as a sovereign people of the state not to allow the enforcement of this law. I'm not going to talk about this too much tonight because of the time issue, and I want to have time to discuss things with you. But this is covered, I think, reasonably well in the book, and I give it as an example because here's a case where you have a state actually declaring a federal law unconstitutional. And it's a law that involves slavery, but not in the way people think. It wasn't actually to defend slavery, but to oppose it that Wisconsin fought against a federal law. Okay, now it's very important that we understand this point here. And there's a whole chapter on it in the book. So if you didn't have time to get to this, definitely make sure you read chapter 4, because you're going to notice that all these debates that we're talking about, they're all going to be, ultimately, it's all going to come down to one of the people is a compact theorist and one's a nationalist theorist. Jackson / Livingston is their nationalist theorists, and Littleton Waller Tazewell is a compact theorist. Joseph Story is a nationalist, Abel Upshur is a compact theorist, and so on and so forth. And so basically what this boils down to is, what is the nature of the United States? What is it fundamentally? Is it one giant blob? Is that what it fundamentally is? Or is it rather fundamentally a collection of societies? And so we see in these debates that we're going to be encountering directly, we see that both sides are trying to make arguments for their side. Now, I have not been able to find a full-fledged, step-by-step exposition of the nationalist theory of the Union until the 1830s. There is no such exposition. However, there are expositions of the compact theory, detailed, that you see in Jefferson and in the whole Jeffersonian tradition. St. George Tucker, who writes his constitutional commentaries, and so on. So, but in any case, the compact theory basically says that the United States was formed when a group of sovereign peoples that had formed state governments instructed those state governments to, at special ratifying conventions, to decide whether or not to ratify the U.S. Constitution. And under those instructions, they decided to indeed ratify it. So they, in fact, endowed this federal government with the limited powers that it enjoys. And so ultimately, it is the states that created this federal government. The states were, in fact, themselves completely independent of each other. They were not part of any one aggregated people in the past. They were separate and distinct in every way imaginable. And they created this union. And they created it basically just to perform limited functions for utilitarian purposes, but that they intended to exert their authority over domestic concerns themselves. And the compact theorists point specifically to the fact that when the Constitution was being ratified, there was no nationwide vote that was held on the Constitution. It was, as the nationalist theory, which we'll get to in a minute, would seem to demand. Instead, it was each state one at a time ratified the Constitution, and that indicates to them that the states as independent political entities are the fundamental building blocks of the Union. The Union is not built out of a bunch of an arbitrary group of individuals. It's built out of states. And so the states are the creators of the Union. See how this is, it's not indispensable to nullification, but it lends it a certain plausibility. The states are the creators of the Union. So how can the Union tell the states what the Union is? The states created the thing. So that if there's a dispute over power, you don't consult the thing you created. You consult the creators. Okay, so the people, the entities you would refer to if there's a dispute would be your fellow states. Okay, well, you know, you ask your fellow states, well, did we in fact intend to give this thing this power or not? You wouldn't ask this thing, hey, what power do you think you have? It's no, you ask each other, well, what power did we indeed intend to give? And if we intended to give it this power and we just didn't get that, then fair enough, but we got to decide that among ourselves. So the nationalist theory, by contrast, argues that the United States is indeed a single whole, and after all, in the preamble to the Constitution, it says, we the people of the United States. It does not say we the states. It says we the people of the United States. So it is speaking of a single whole. And then it argues a lot of times on the basis of plausibility. It's just not plausible. It would be impractical if we had a bunch of sovereign entities, that the states have yielded a portion of their sovereignty to the federal government. The states do not have the power to judge the constitutionality of the actions of the federal government. So these are the sorts of arguments that are made, and they then proceed to say, look, the whole people passed the laws. The whole people created the Union, and the whole people, through their voice in Washington, the Congress and the President, they passed the laws. So how can one state undo what the whole people has done? So they think in terms of one whole people. And so if a state were to nullify a federal law, in the nationalist view, what's actually happening here is it's just an arbitrary group of individuals refusing to abide by what the whole people have said is their will. We can't have that. That's unjustifiable insubordination. Now, I just do want to make two quick points here. Now, obviously, I'm coming at this from the point of view of somebody who is persuaded of the rightness of state nullification, but I do want to look at both sides honestly and weigh the strengths and weaknesses of the two sides, and we will indeed do that as the weeks go on. But I do want you to be aware of 2 points. Number one is that the argument from the preamble does not work, as I pointed out in the book, and I want to elaborate on what I said in the book here. Daniel Webster, a U.S. Senator whom we're going to encounter, does indeed point to this and says, look, we the people, it's one united people. These states are not independent and sovereign. It was the whole people that created the Union. It wasn't the states that created it. The whole people created the Union. So the people can decide on constitutionality through the federal government that represents them, the people, but not the states. States didn't do it. We the people, says it right in there. The problem is that, as I show in the book, the we the people thing initially was we the states, and then they listed all the states. But then, of course, nobody knows in advance which states are going to ratify, so you can't take their ratification for granted in the document. So it was decided, all right, well, we'll change it to we the people. But you can tell from the context that people always meant the people of Massachusetts, the people of South Carolina, the people of Virginia, the people of New York. The peoples are the individual peoples of the states, not a single people in the aggregate. And we know that because if that was what was meant, this is a completely revolutionary change in the whole nature of the document. And yet, when that change was introduced into the Constitution was introduced by the Committee on Style. Now, the Committee on Style doesn't have substantive powers, and it was approved with no dissent whatsoever. So, and we know this from the proceedings of the Constitution. James Madison, of course, took copious notes of the proceedings. Well, Webster didn't have access to those notes at the time he was making that argument, and those notes just completely refute this argument of Webster. But he doesn't know that because those notes don't become available to the general public until 1840. The second thing is, it's worth noting, if you look in the Constitution, all the times that the United States is referred to, it's very interesting to note the United States is always referred to as a they. The United States is not referred to as an it. In fact, the United States are not referred to as an it. They are referred to as a they. And that kind of language is going to be sort of pounced upon by compact theorists as evidence for their position. Finally, just placing this in philosophical context, I want to note that, and here I'm deeply indebted to retired Professor Emeritus at Emory University, Donald Livingston, who happens to be a great David Hume scholar, who was indeed one political philosopher who dissented from this. But if you look at modern political philosophy, all of it takes for granted the presuppositions that go into what became the nationalist theory of the American Union. Every one of them takes it for granted. And this is what everyone takes for granted today, the idea that every society must be organized with one single, irresistible, infallible, indestructible power center at the center. And any subsidiary body must be completely subordinate to it. That's just the way it is. We can't have an imperium in imperio. We have to have just one irresistible power center. Everyone takes that for granted. Everyone in American society takes that for granted. Every politician takes it for granted. Everybody assumes that. That was not assumed in European civilization prior to this, prior to the modern period. To the contrary, if you look at Johannes Althusius, who was a theorist of the Dutch Federation in the 17th century, he views political association as consisting of a group of communities, of families that form, that combine together to form villages that form together to form provinces, provinces that form together to form provincial councils, and so on and on. And each one of these enjoys an integrity and liberties and powers of its own. And so in that kind of setup, you can imagine a secession, because you have a series of groups that each consensually agree to form larger groups and so on. Whereas the modern view that originates with Thomas Hobbes in his book Leviathan, 1651, is that no, the modern political organization derives from just a group of individuals, isolated individuals, not people who belong to particular social authorities, not churches, universities, towns, cities, competing courts, nothing like that. You're just an individual, stripped of any allegiances. You're just a bunch of individuals, and these bunch of individuals compact among each other to establish a sovereign office, a sovereign political office that will rule over them. And so instead of there being, as in Althusius's view, a series of layers of society, the Hobbesian view conceives of society as being a single flat plane. And so in this sort of society, which is the society we live in now, it becomes unthinkable to imagine that a subsidiary body could actually negate what the central authority is telling it. This just doesn't compute in people's heads. It's not what they were taught in school. And yet this is the mainstream of what all political philosophers think. So nullification is not just some cutesy little thing that a few people thought up. It is a dagger. It's not quite a Rothbardian dagger. I mean, not many things are. But nevertheless, it is a clear shot against the unexamined premises of all modern political philosophy. And that's the significance of it, ultimately. And finally, this is what we'll, I hope, have time to talk about tonight. After we do some questions, we can talk among ourselves about this, because some of these questions, historical matters, constitutional matters, I'll do my best to answer. But then when it comes to some of these things, I think it's much better, I'll give my answer, but it's better for us to discuss it and to have some give and take here. Can these ideas make a comeback today? Is it possible? What about the states having their so-called federal funding taken away? If they resist the federal government, what if the federal government says, okay, you're not getting your highway money anymore? Because the federal government has a direct hand in the individual's pocket now. You can just take money away and not give it back. What about the federal government threatening to use physical force against a state? Is that conceivable? Can we overcome these problems through strength in numbers, through a whole bunch of states together saying we're not going to do this particular thing, so what are you going to do to us? Somebody asked about the repeal amendment, which I mentioned in my book. I'll address that. The repeal amendment is a proposal that's gotten a lot of steam out by Professor Randy Barnett, who used to be at Boston University, is now at Georgetown, that says that if a federal law is deemed to be unconstitutional by 2/3 of the states, it is thereby repealed. And I think that bears a family resemblance to the idea to the principles of 98, because it is indeed saying that if the federal government, if it's even conceivable that you might limit it, the limiting has to be done by something other than the federal government itself, and so it should be done by the states.